Hi, this is the business guy with Asset Protection Planners. Let's talk about protecting your personal residence from lawsuits. And I'm not talking about drilling a hole and filling your house with cockroaches so nobody will want to take it away from you like they did in the movie Pacific Heights. So how do you protect your house, your personal residence from creditors when somebody wants to sue you? With your personal residence, there are two things we do. And to give you a little background, I've been in the asset protection field since 1991, that's over 30 years, and our company started in 1906. We have full-time licensed attorneys on staff. I believe at this point we have over 80,000 clients in our database, and we are the nation's leading asset protection firm. So feel free to call us right now for a free consultation. And while you're watching, please hit the like button below. It's a huge help so YouTube promotes this video. And besides, it really makes my heart do flip-flops when you do. Thanks so much. Plus, I really want you to join our community here. And you can do that by hitting the subscribe button so that when more videos come out like this, you'll be up to date right away. So here's what we do to protect your personal residence from lawsuits. Number one, we put your home into a land trust for privacy of ownership. So your name does not appear in the public records when some attorney comes sniffing around for assets to see if they want to accept a contingency fee lawsuit against you. And when it's your personal residence, we don't generally assign the land trust to an LLC. We only do that for rental properties or second homes, and we'll show you why. So the land trust is for privacy of ownership. Number two is for protection. We record an equity stripping lien against your property. That is, mortgages or deeds of trust to pull out the equity, and we do that for most people who live in states that don't protect enough of your home equity. Now, number one and number two work in about 99% of the cases. But in about 1% of the cases, we later get a third-party lender to purchase those liens and put the proceeds into an inaccessible account in an international asset protection trust. Now, the personal residence strategy is different from protecting real estate investments, rental properties, and so on. And this is because your personal residence is in a different tax and legal category. With rental properties, we set up land trusts for privacy of ownership, and then we set up LLCs, and you assign the land trust to the LLC for lawsuit protection and asset protection. See our video on this topic. Now, the LLC doesn't work on the home where you live for two big reasons. Number one, for tax reasons. You would lose your mortgage interest write-off. As you probably know, when you own a home, you get a write-off of your mortgage interest to a certain limit. You would lose that if your property was in an LLC or a land trust with an LLC as a beneficiary, because the IRS could say that you're simply a tenant of the LLC. So the land trust / LLC combination works great for rental property, but not for the house where you live. Plus, when you sell your home for a profit, if you've lived there for a couple of years, you get a huge exemption on your taxes. Under the current Section 121 exclusion, you get to put $250,000 of tax-free profits in your pocket if you're single, and $500,000 if you're married. You must have lived in the house for 2 out of the last 5 years. So you can do that every 2 years, so that's huge. Now, you don't get that benefit on places where you never lived, such as rental properties that you may own, and you can lose that big tax break if the ultimate owner of your residence is an LLC. Again, the LLC works on investment properties, but not on your home, because the IRS gives different tax breaks to your personal residence than they do to your income-producing properties where you don't live. Now, there is an exception to this. Treasury regulations allow for the interest write-off and the capital gains exclusion when the title is held by a single-member disregarded entity. See 26 CFR Section 1.121-1. The problem is that only 5 states recognize single-member LLC charging order protection. So if one person owns the LLC, the person suing you theoretically cannot take away the LLC or your home that you hold inside of the LLC. And single-member charging order protection is available in Alaska, Delaware, Nevada, South Dakota, and Wyoming. It doesn't work if your primary residence is outside of one of these states, because the judge will just apply the LLC law to the state where the property is located, even if you put it into an LLC from one of these states. Plus, we're talking about a single-member LLC, and people who are married typically want both spouses to have a vested interest in the property, not just one of the spouses. That is, which states have both single-member charging order protection and are community property states for IRS purposes. It gets even deeper. The IRS has issued a special rule applicable to LLCs owned by married couples who live in community property states. Under this rule, a married couple can treat their jointly owned business as a disregarded entity or as a single member LLC for federal tax purposes. Well, keep in mind there are only 9 community property states. So where do these two intersect? Where do you get both multi-member charging order protection and a community property state? So a married couple can own their personal residence in an LLC and still get the homeownership tax benefits in these community property states. And these states are Washington, Idaho, Nevada, California, Arizona, New Mexico, Texas, Louisiana, and Wisconsin. In these states, a husband and a wife can own an LLC, and that LLC can own a home, and they can have a semblance of charging order protection against the LLC. And I would not do this in Texas where you already have 100% homestead protection. And I would also hesitate to do this if you have very little equity in your home, as in Nevada, where you have homestead protection that secures $550,000 of equity, and in California, that depending on your county, $300,000 to $600,000 with automatic adjustments each year for inflation. And before you follow any of this information, make sure to check with a licensed CPA first. We also have licensed attorneys and consultants on staff that you can call at the number below if you want to take advantage of any of these things that we're talking about here. Okay, so the loss of personal residence tax breaks is reason number 1 why we don't put your home into an LLC in most states. Reason number 2 that we don't generally put your personal residence into an LLC is the homestead exemption. Google the term homestead protection by state, and you see our website with our homestead protection video. On that page, you'll see a state-by-state chart of how much equity the law protects in each state. In Florida, where I live, for example, if you have half an acre or less in a city or 160 acres outside of the city limits, you can protect 100% of your equity from creditors. Actor Burt Reynolds was $5 million in debt when he bought a mansion just north of me in Jupiter, Florida. And at the moment, O.J. Simpson still owes over $35 million to the families of Nicole Brown Simpson and Ronald Goldman. He initially moved to Florida to protect his assets in his primary residence. You lose that protection if you put your home into a company. In Virginia, if a married couple gets into a lawsuit together and they have $1 million home, the creditor gets $990,000 and the couple only gets $10,000 because that's the homestead protection limit in Virginia. In New Jersey and Pennsylvania, you don't get any protection at all. So how can we lose our homes? The most common way is personal liability. You get into a car crash and you have $500,000 of insurance, but you get a judgment against you for $2 million. Happens every day of the week. Just about all of the accident attorneys that you see on TV and billboards take their cases on a contingency fee basis. So the first thing they'll do is go after the insurance, and then the next thing they do is go after your real estate and your bank account. And they usually won't even take a case unless they find your assets first. And they have no more sympathy for you than a pack of lions has for the baby gazelle. Hey, you're just their next meal. And if they don't get it from you or somebody like you, they don't eat. Plus, the judgment they slap on your house gets 10 to 12% bigger every year. And that's the interest rate on civil judgments. So as you're paying your mortgage down, the judgment goes up, and it just gets better and better for your creditor whenever you try to sell or refinance. Or they just foreclose on your property and forcefully rip it out from underneath you. So that's why we first set up a land trust, and you put your home into the land trust, and then we set up a Wyoming LLC, not to own it, but to act as trustee of the land trust. And that's fine, even on your personal residence. The Wyoming LLC should not be the beneficiary of your land trust if it's your home, but it's okay if it's the trustee. So let's say the name of your trust is the 123 Maple Street Trust, and we'll call your Wyoming company Prime Properties LLC, and both of those names are on the deed in the public records instead of your name. So if these are your names, the title of your house used to read John Smith and Mary Smith, and now it reads 123 Maple Street Trust, Prime Properties LLC, a Wyoming LLC trustee. So when somebody searches for your assets, they find nothing. The second thing we do is set up another LLC, and we record an equity line of credit mortgage against your home. Not the same LLC that serves as your trustee, because that would simply be a lender lending to itself, and that would be an invalid mortgage. So we set up another LLC, preferably an offshore LLC, owned by your offshore asset protection trust, and we use that to record a mortgage against your home. Again, that is an equity line of credit, so there's no money changing hands. It's like getting an equity line of credit from Bank of America and they record a mortgage against your property, but no money changes hands until you pull some money out of the credit line. Same thing here. No money changes hands until you decide to have your offshore LLC sell the mortgage to one of our offshore lenders. And the proceeds go into your offshore asset protection trust that nobody can touch. You would not be able to run away and spend this money because that would be too risky to the lender. But what it does is it shows the judge you recorded a mortgage against your house, you sold the mortgage to a third-party lender, and this happens all the time, one lender buying a mortgage from another, and you received the proceeds in your trust. So you have a legitimate third-party mortgage. So when you sell or refinance your house, the mortgage gets paid off offshore, and the money goes into an offshore account that you can touch, but nobody else can, including your creditor. Plus, when somebody records a judgment in the county recorder's office, if you don't have the house in your own name, it doesn't automatically attach to the house. They would have to jump through all kinds of legal hoops to get to the house. Meanwhile, you're getting the third-party lender involved to suck out all the equity. Now, if you live in a state such as Arkansas, Florida, Iowa, Kansas, Oklahoma, South Dakota, Texas, or DC, or under the Puerto Rico safe home laws, you get 100% protection, so you would not use these strategies in these places. But if you think you can sell your house and move to one of these states once you cash out, they can immediately yank it out of your bank account or ask the judge to freeze your assets before you do. So the key thing about asset protection is to act immediately. We have two kinds of prospective clients. Ones that see the threat and act immediately, and ones that procrastinate themselves into the poorhouse. Let me think about it. I want to talk to a CPA. I want to talk to my cousin Bobo, the attorney. Do they specialize in asset protection? No. Well, right now you're talking to an asset protection attorney who does. You obviously need to do this. So let me send it to you in writing, what we're going to do, and get started. In fact, just recently, we had one of our staff attorneys have a client text him who wanted to talk to his lawyer first. Now, here is the string of texts. Our attorney, did you hear back from your lawyer? Waiting. Our attorney, courtesy response, please. Our attorney, hello? Prospective client, moot point, I've been served. Our attorney, did the summons include a freeze on your assets? Prospective client, yes. You see, too late. Nothing we can do. So when you need asset protection, get it set up immediately. You have this tiny bump on your nose. You don't wait until your cancer is stage 4 when you have 2 months to live before you have it taken care of. Same thing here. You don't head scratch until you have a noose around your neck. When you need asset protection, get on it. Just get it done. Call us and we can help you do that. So the key thing is the land trust and lien strategy simply works. You're putting up a fight and not just laying out in the middle of the street naked yelling, kick me. Don't be a victim. Put up a fight and do it right away. Then when you do, you either lose nothing or you use it as leverage to negotiate a settlement for pennies on the dollar. It puts you in the driver's seat instead of the greedy maniac who sued you. So give us a call, fill out a free consultation form on our website. Remember to click the like button and subscribe below. Thanks for watching. This is The Business Guy.